Thus, one may well ask why Jackson was so willing to join the Warren opinion when it differed in several material respects from his own views. The Warren opinion, for example, treated the history of the 14th Amendment as equivocal, whereas Jackson thought it quite clear that the framers did not intend to wipe out segregation. The Warren opinion relied in part on sociological studies that Jackson apparently thought were not a proper element of equal protection. And most importantly, Warren based his conclusion primarily on the harm that segregation did to Negro children, whereas Jackson based his on the disappearance over time of any claim that the two races were constitutionally unequal. I think the answer to why Jackson was willing to join Warren despite these differences is that Jackson liked the simplicity and directness of the Warren opinion. He thought even laymen could understand it, and as I have said, he was gratified that it did not place blame on anyone. Now remember, unanimity of the justices was not yet realistically expected. As a footnote, it's interesting that so much emphasis in the commentaries has been placed on the non-legal sources used by Warren, such as the social studies showing the adverse impact of segregation on Negro children. We who were there know that these studies were added almost as an afterthought and were not critical to the underlying thesis. Very little attention has been paid to other outside the record sources that the parties were not even aware of at the time, and that may have had more significance for both the opinion on the merits and the ultimate decree. Several groups of law clerks conducted studies outside the record. One of these was Alex Bickle's 63-page history of the 14th Amendment, and another was my own commentary on maps I had gathered showing the precise location in certain cities of Negro and white houses and schools. The memorandum I wrote in response to Jackson's draft opinion took issue with several of his points and with the draft's structure. Richard Kluger, in his splendid book, Simple Justice, gives me credit for Jackson's decision to write no more. But another contemporaneous memo I wrote indicates that Jackson fully intended to redo his draft, but was interrupted both by his illness and by Warren's opinion. In any event, as you all know, Jackson joined with the other 8 members of the court in the unanimous Brown decision. In an otherwise very fine article in the 1989 yearbook of the Supreme Court Historical Society, Jeffrey Hockett concludes that, quote, Jackson's argument for ending segregation was less susceptible to criticism than Warren's, unquote. While no one admired Justice Jackson more than I did, I have to disagree with this conclusion. The Justice's final unpublished draft opinion was well written, as one would expect, clear, lucid, and fully cognizant of all the problems attending the rational resolution of the cases. If anything, however, it was too forthright in light of the people it was trying to reach. Not only would it have been attacked, as Warren's was, but many of its points would have been used by segregationists to bolster their cause. This may have been one of those very, very rare occasions when it was to the nation's interest not to have Justice Jackson fighting for the court. And I really think Robert H. Jackson would agree with that conclusion. Thank you very much.
Wow.